Question 1. In an environment where different components must interact efficiently, a multinational corporation has implemented strict cybersecurity measures to protect its trade secrets. However, a foreign competitor allegedly obtained confidential research and development data by bribing an employee with access to the company's proprietary database. The corporation seeks legal remedies under U.S. law. Which legal provision is the most appropriate for criminal prosecution in this case? A. Uniform Trade Secrets Act UTSA. B. Economic Espionage Act EA. C. Defend Trade Secrets Act DTSA. D. Federal Computer Fraud and Abuse Act CFA. Answer B. Economic Espionage Act EA. Explanation: the Economic Espionage Act EA, codified in 18 U.S.C. SSS 1831-1839, criminalizes trade secret theft, particularly when foreign entities are involved. Section 1831 specifically targets economic espionage benefiting foreign governments, companies, or agents. The bribing of an employee to obtain trade secrets suggests an intentional act of misappropriation with potential international implications. Why other options are incorrect? A. UTSA. The Uniform Secrets Act is civil law framework adopted by states to provide trade secret protection but does not address criminal prosecution. C. DTSA. The Defend Trade Secrets Act allows private entities to pursue civil remedies, but it does not impose criminal penalties like the EA. D. CFA. The Computer Fraud and Abuse Act addresses unauthorized access to protected computers, but does not specifically target bribery or economic espionage. EA provides the strongest basis for criminal prosecution, particularly since the case involves foreign competitor attempting to unlawfully acquire sensitive information. Question 2. During a major transformation where existing methods of protecting trade secrets are being reassessed, a technology company implements a policy requiring employees to sign non-compete agreements. A former employee joins a competitor in a similar industry and the company sues, claiming the ex-employee's new role poses a risk of trade secret misappropriation. Under what legal doctrine could the company argue for an injunction against the former employee's new employment? A. Inevitability of disclosure doctrine. B. Preemption doctrine under UTSA. C. Work for hire doctrine. D. No challenge clause doctrine. Answer A. Inevitability of disclosure doctrine. Explanation: the inevitability of disclosure doctrine allows employers to seek an injunction preventing a former employee from working for a competitor if the employee's knowledge of trade secrets makes it impossible to avoid misappropriation even without actual theft. This doctrine is recognized in some U.S. jurisdictions, though not universally adopted. Why other options are incorrect? B. Preemption doctrine under UTSA. The UTSA preempts conflicting common law claims but does not grant an independent right to prevent employment based on inevitable disclosure. C. Work for hire doctrine. This doctrine applies to copyright ownership for works created during employment, not to trade secret misappropriation. D. No challenge clause doctrine. This doctrine relates to contractual provisions preventing patent challenges, not trade secret protection in employment. Employers invoking the inevitability of disclosure doctrine must demonstrate that the former employee's knowledge of proprietary information would inevitably be used in the new position, posing risk to trade secret security. Question 3. While investigating a complicated issue between different departments of a company, it is discovered that an external consultant inadvertently received a set of confidential documents containing proprietary formulas. The consultant had no intention of using or disclosing the information and promptly returned it. However, the company is considering legal action. Under the Defend Trade Secrets Act DTSA, what is the most relevant defense the consultant could assert? A. The consultant did not engage in willful misappropriation. B. The information was obtained through reverse engineering. C. The consultant qualifies for whistleblower immunity under the DTSA. D. The company failed to take reasonable steps to protect the trade secrets. Answer A. The consultant did not engage in willful misappropriation. Explanation: the Defend Trade Secrets Act DTSA requires intentional or willful misappropriation for liability to apply. If the consultant inadvertently received confidential information, took no action to use or disclose it, and promptly returned it, they have a strong defense against a trade secret claim. Why other options are incorrect? B. Reverse engineering. This is a legitimate way to acquire trade secrets but it is not applicable here since the consultant received the information unintentionally. See whistleblower immunity. DTSA provides immunity for whistleblowers reporting violations of the law but does not protect accidental recipients of trade secrets. D. Lack of reasonable steps to protect secrets. While reasonable efforts are required to maintain secrecy, their absence does not necessarily excuse unintentional recipients' legal obligations. The key takeaway is that accidental receipt alone does not constitute misappropriation under the DTSA. Misappropriation requires improper acquisition, disclosure, or use of trade secrets. Question 4. During a critical transition period where existing processes are being overhauled to improve trade secret protection, a multinational corporation discovers that an employee has accessed a confidential database containing proprietary formulas without authorization. The employee claims that they did not share or disclose any of the information and that mere access does not constitute misappropriation under trade secret law. The company considering legal action but is unsure whether unauthorized access alone is sufficient for a claim of trade secret misappropriation. Given the legal frameworks governing trade secrets, including the Uniform Trade Secrets Act (UTSA) and the Defend Trade Secrets Act (DTSA), which of the following statements best represents the company's legal standing? A. Unauthorized access without actual disclosure or use is insufficient to constitute misappropriation under both UTSA and DTSA. B. The DTSA allows for claim of misappropriation based on improper acquisition, even without disclosure or use if the access was unauthorized. C. Misappropriation under UTSA requires proof of financial harm to the trade secret owner, making claim in this scenario difficult. D. Since the employee did share the trade secrets, the company can only pursue internal disciplinary action, not legal action under trade secret law. Answer B. The DTSA allows for a claim of misappropriation based on improper acquisition, even without disclosure or use if the access was unauthorized. Explanation. Under the Defend Trade Secrets Act (DTSA) and Uniform Trade Secrets Act (UTSA), misappropriation is broadly defined and includes the acquisition of a trade secret through improper means. The key element in this case is that the access was unauthorized. The DTSA provides that improper acquisition, even without use or disclosure, constitutes misappropriation if the information is obtained through unlawful means such as hacking or unauthorized access to confidential databases. Courts have ruled that unauthorized access itself can be sufficient to establish an improper means of acquisition, particularly in digital trade secret cases, e.g. Epic Systems Corp. v. Toller Consultancy Services Limited. Option A is incorrect because both UTSA and DTSA recognize improper acquisition as a basis for misappropriation without requiring disclosure or use. Option C is incorrect because proving financial harm is not a prerequisite for a trade secret misappropriation claim. Rather, it affects the damages awarded. Option D is incorrect because while the company may impose internal sanctions, the employee's unauthorized access creates legal liability under trade secret laws. Question 5. In a high-stakes environment where multiple challenges arise in protecting trade secrets, a technology startup enters into discussions with a venture capital firm regarding potential investment. As part of the due diligence process, the startup shares confidential details about its proprietary software algorithms. The venture capital firm later decides not to invest but subsequently funds a competitor that develops a strikingly similar product. Startup suspects that its trade secrets were misappropriated but realizes it never required the venture capital firm to sign a non-disclosure agreement (NDA). What legal options are available under trade secret law? A. Without an NDA, the startup has no legal recourse because trade secret protection requires contractual obligations of confidentiality. B. The startup may still have a claim under the UTSA and DTSA if it can prove that the information was disclosed under circumstances creating an implied duty of confidentiality. C. Trade secret protection only applies in cases of theft, not voluntary disclosure, so the startup has no claim. D. Because the startup did not secure a patent, its only remedy is to seek a competitive advantage in the marketplace. Answer B. The startup may still have a claim under the UTSA and DTSA if it can prove that the information was disclosed under circumstances creating an implied duty of confidentiality. Explanation. Trade secret law under the UTSA and DTSA does not require an NDA for protection, although having one strengthens a claim. Courts recognize that even in the absence of an NDA, an implied duty of confidentiality may exist in negotiations. Factors such as the nature of the relationship, verbal assurances of confidentiality, and industry standards can establish an expectation of secrecy. See Silvaco Data Systems v. Intel Corp. Option A is incorrect because while an NDA is highly advisable, its absence does not automatically eliminate trade secret protection. Option C is incorrect because misappropriation can occur through improper use of voluntarily disclosed trade secrets, particularly when an implied duty exists. Option D is incorrect because patents and trade secrets are separate forms of protection. The lack of a patent does not negate potential legal action under trade secret law. Question 6. While analyzing the root causes of sequential problems in trade secret enforcement, a manufacturing company faces a dilemma. It has strong cybersecurity measures in place, yet a former employee left with proprietary product design files saved on a personal device. The employee claims they have not disclosed or used the information and that they simply forgot to delete it. The company is preparing a trade secret misappropriation lawsuit under the DSA. What is the key legal issue in determining whether the employee has misappropriated the company's trade secrets? A. Whether the employee had the intent to use or disclose the information for personal or competitive gain. B. Whether the company can prove the employee's access violated an explicit cybersecurity policy. C. Whether the former employee had contractual obligation not to retain company information after termination. D. Whether possession of the trade secrets alone, even without use or disclosure, constitutes misappropriation. Answer: D. Whether possession of the trade secrets alone, even without use or disclosure, constitutes misappropriation. Explanation: under the DSA, misappropriation includes acquisition by improper means, which can occur if an employee takes confidential information without authorization or exceeding authorized access. Courts have ruled that retaining trade secrets post-employment, even without use, can constitute misappropriation because the rightful owner of full control over the information. See Wemo LLC v. Uber Technologies Inc. Option A is incorrect because intent is not a required element under DSA. Mere possession can be enough for a claim. Option B is incorrect because cybersecurity policies strengthen a case but are not the primary legal issue. Option C is incorrect because contractual obligations like NDAS are not required for a misappropriation claim, although they provide additional legal grounds. Question 7. During an emergency response where multiple areas are impacted by a suspected cybersecurity breach, a pharmaceutical company learns that hackers accessed a database containing critical drug formulas. The company immediately implements stronger encryption and notifies employees, but delays reporting the breach to law enforcement, fearing reputational harm. Months later, a competitor releases a nearly identical drug formulation. Company now seeks legal action under the Economic Espionage Act, EAR. What is a key challenge the company may face in proving its case? A. The company must prove that the trade secret was used by the competitor, not just stolen. B. The delayed response in reporting the breach may weaken its claim that the information was adequately protected as a trade secret. C. The EAR applies only to physical trade secret theft, not cybersecurity-related misappropriation. D. A drug formulation cannot be protected as a trade secret if it is subject to FDA approval. Answer: B. The delayed response in reporting the breach may weaken its claim that the information was adequately protected as a trade secret. Explanation: under the Economic Espionage Act, EAR, a trade secret owner must demonstrate that reasonable measures were taken to maintain secrecy. A delayed response or failure to report the breach could weaken the argument that the company actively protected its trade secrets. See U.S. v. Aleinikow. Option A is incorrect because the EAR criminalizes unauthorized acquisition, not just use. Option C is incorrect because the EAR applies to digital theft, including cybersecurity breaches. Option D is incorrect because drug formulations can be protected as trade secrets until publicly disclosed through regulatory filings. Question 8. During a comprehensive security review where multiple vulnerabilities are identified, a global financial institution discovers that a former administrator copied customer encryption keys to an external drive before resigning. The administrator insists that they have not shared or used the information, arguing that no harm has occurred. Given the legal definitions of trade secret misappropriation under the Defend Trade Secrets DSA, what is the most appropriate legal action the company can take? A. The company cannot take action because no actual damage has been caused by the administrator's actions. B. The company can seek an injunction under the DSA even if no financial harm has yet occurred to prevent potential future disclosure. C. The company can only act if the administrator was contractually obligated under non-disclosure agreement (NDA). D. The DSA applies only to theft by third parties, not by former employees, so the company must rely on internal disciplinary actions. Answer: B. The company can seek an injunction under the Dietze even if no financial harm has yet occurred to prevent potential future disclosure. Explanation: the Defend Trade Secrets Act Dietze allows for legal action against misappropriation, which includes improper acquisition, use, or disclosure of trade secrets. In this case, even though the former administrator has not disclosed or used the encryption keys, their unauthorized copy. Confidential data constitutes improper acquisition, which qualifies as misappropriation under Dietze. Courts have ruled that an injunction can be granted to prevent potential harm even if financial loss has not yet occurred. See Wemo LLC v. Uber Technologies Inc. Option A is incorrect because harm is not a required element for a Issei claim. The mere unauthorized acquisition of trade secrets is sufficient. Option C is incorrect because an NDA is not required for Dietze protection, though it strengthens legal standing. Option D is incorrect because Dietze explicitly applies to employee misconduct as well as third-party theft. Question 9. While analyzing the root causes of operational inefficiencies, a healthcare company realizes that a third-party vendor has been storing patient records on an unsecured cloud server. The records include proprietary algorithms for diagnosing rare diseases, which are considered trade secrets. Competitors could potentially access this information. What key factor determines whether the healthcare company can claim trade secret protection? A. Whether the company made reasonable efforts to maintain the secrecy of the proprietary algorithms. B. Whether the vendor had an NDA explicitly stating the trade secrets should be protected. C. Whether the trade secrets have already been published in medical journals. D. Whether competitors have developed similar diagnostic algorithms independently. Answer: A. Whether the company made reasonable efforts to maintain the secrecy of the proprietary algorithms. Explanation: to qualify for trade secret protection under the Dietze and Nutzer, a company must show that reasonable measures were taken to keep the information confidential. Courts have ruled that failure to implement security protocols, such as encryption or vendor restrictions, may weaken trade secret claims. See Mediweight Loss Franchising LLC v. Sadek. Option B is incorrect because an NDA is helpful but not required. The legal standard is whether the owner took reasonable efforts to maintain secrecy. Option C is incorrect because if the information was publicly disclosed, it loses trade secret status. Option D is incorrect because independent discovery does not negate misappropriation claims if the information was improperly obtained. Question 10. In an environment where confidentiality agreements are frequently challenged, a software company sues a former employee for launching a competing product using similar code. The employee argues that they wrote the code from memory and did not use any confidential company materials. What is the critical factor in determining whether trade secret misappropriation occurred? A. Whether the new product's code is identical to the company's code. B. Whether the former employee had access to and knowledge of the trade secret before leaving. C. Whether the company's code was registered for copyright protection. D. Whether the employee developed the competing product while still employed. Answer: B. Whether the former employee had access to and knowledge of the trade secret before leaving. Explanation: courts have ruled that trade secret misappropriation can occur even if an employee relies on memory rather than copying physical documents. If the employee had prior access to and knowledge of confidential information and used it to create a competing product, misappropriation can be established. See PepsiCo Inc. v. Redmond. Option A is incorrect because identical copying is not necessary. Misappropriation can occur even if the new product is similar but not identical. Option C is incorrect because trade secret protection is separate from copyright. Option D is incorrect because misappropriation can occur even after employment ends. Question 11. While evaluating risk factors that impact trade secret security, an aerospace company discovers that one of its engineers has been secretly consulting for a foreign competitor. The competitor has recently developed technology strikingly similar to the company's proprietary aircraft design. What legal strategies can the company pursue under U.S. trade secret laws? A. Seek an injunction and damages under the Dietze, arguing that the engineer misappropriated trade secrets through unauthorized disclosure. B. File complaint under the Economic Espionage Act, but only if the foreign competitor is government-funded. C. Take no legal action unless there is direct evidence that the engineer physically took documents. D. Rely on patent law instead, as trade secrets do not protect technical designs. Answer: A. Seek an injunction and damages under the Dietze, arguing that the engineer misappropriated trade secrets through unauthorized disclosure. Explanation. The DSA allows for legal action against employees who improperly disclose trade secrets even without physical theft. Courts recognize that unauthorized consulting can constitute trade secret misappropriation if confidential knowledge is transferred. See United States v. Gin. Option B is incorrect because the Economic Espionage Act applies regardless of government funding. Option C is incorrect because misappropriation includes unauthorized disclosure, not just physical theft. Option D is incorrect because trade secrets do protect technical designs if they are kept confidential. Question 12. During an intellectual property audit, a pharmaceutical company realizes that a departing research scientist downloaded confidential drug formulae before resigning. The company is concerned that the scientist might share this information with a competitor. What immediate legal action should the company take to protect its trade secrets? A. Seek an ex parte seizure order under the DSA to recover the downloaded files before they can be disclosed. B. File a copyright infringement lawsuit since the drug formulae are intellectual property. C. Issue a cease and desist letter to the scientist and wait for evidence of actual disclosure. D. Take no action unless the competitor releases a similar drug within the next 2 years. Answer A. Seek an ex parte seizure order under the DSA to recover the downloaded files before they can be disclosed. Explanation. Under the Defend Trade Secrets Act DSA, companies can seek an ex parte seizure order which allows law enforcement to confiscate misappropriated trade secrets without notifying the defendant. This is particularly useful when there is a risk of irreversible harm due to disclosure. Courts have ruled that preempt action is crucial when employees take confidential data before leaving. See Mission Measurement Court v. Blackboarding. Option B is incorrect because copyright law does not protect trade secrets. It applies to publicly disclosed works while trade secrets rely on confidentiality. Option C is incorrect because waiting for actual disclosure may be too late to prevent damage. Option D is incorrect because trade secret protection does not require proof of financial harm, only unauthorized use or disclosure. Question 13. While negotiating a merger, the technology firm shares sensitive AI algorithms with a potential buyer under a non-disclosure agreement (NDA). The deal falls through, but 6 months later, the buyer launches a competing product with remarkably similar algorithms. What legal principles would determine if trade secret misappropriation occurred? A. Whether the buyer independently developed the algorithms before receiving the information. B. Whether the NDA explicitly prohibits the use of trade secrets after the termination of negotiations. C. Whether the buyer was legally required to destroy or return all confidential materials after the deal collapsed. D. Whether the algorithms were patented before the merger discussions. Answer A. Whether the buyer independently developed the algorithms before receiving the information. Explanation. Trade secret misappropriation under the UTSA and DSA depends on whether the recipient acquired, used, or disclosed the information improperly. If the buyer independently developed the algorithms before receiving the firm's confidential data, misappropriation did not occur. However, if the buyer used confidential knowledge gained negotiations, this would constitute misappropriation. See Gen and Tech Inc. HLIO Tech Inc. Option B is incorrect because an NDA does not override trade secret law. Misappropriation can occur even if the NDA is vague. Option C is incorrect because failure to return or destroy materials does not prove use or disclosure. Option D is incorrect because patents and trade secrets are separate protections. Patent would make the information public, eliminating trade secret status. Question 14. When investigating a data breach, a cybersecurity firm discovers that a competitor has been systematically hiring employees from the firm's engineering division. These employees had access to proprietary encryption algorithms, and the competitor's new software appears to incorporate the firm's trade secrets. What factors would court consider in determining misappropriation? A. Whether the former employees had written agreements prohibiting them from working for competitors. B. Whether the competitor actively solicited confidential knowledge from the former employees. C. Whether the firm's trade secrets were patented before the employees left. D. Whether the competitor's product is identical to the firm's encryption algorithms. Answer B. Whether the competitor actively solicited confidential knowledge from the former employees. Explanation. Courts assess trade secret misappropriation based on intent and improper acquisition. If the competitor specifically hired employees to extract confidential information, this could constitute misappropriation. See PepsiCo Inc. v. Redmond. Direct evidence, such as emails or interviews, would strengthen the case. Option A is incorrect because the non-compete agreement is not necessary for a trade secret claim, although it can help. Option C is incorrect because patents and trade secrets are different forms of protection. Option D is incorrect because trade secret misappropriation does not require identical copying. Use of confidential techniques is enough. Question 15. A startup specializing in autonomous vehicle technology hires a software engineer from a major competitor. Shortly after, the startup makes significant advancements in sensor technology similar to the competitor's proprietary methods. The competitor alleges trade secret theft. What is the most critical defense the startup could use? A. The new sensor technology was developed through independent research without using the competitor's trade secrets. B. The competitor failed to register the sensor technology as trade secret with the government. C. The software engineer did not sign non-compete agreement before leaving the competitor. D. The competitor's sensor technology is already widely known in the industry. Answer A. The new sensor technology was developed through independent research without using the competitor's trade secrets. Explanation: the strongest defense against trade secret claim is independent development. If the startup can prove that its advancements were made without using the former employer's confidential information, then no misappropriation occurred. Courts recognize that similar innovations can arise independently. See Edwards v. Arthur Anderson LLP. Option B is incorrect because trade secrets do not require government registration. Option C is incorrect because non-compete is not necessary for trade secret protection. Option D is incorrect because if the information is widely known, it would not qualify as trade secret in the first place. Question 16. An aerospace company is suing a former supplier for misappropriating proprietary aircraft wing designs. The supplier argues that the company's design techniques were not trade secrets because they were reverse engineered from publicly available aircraft models. What key legal principle applies in this case? A. Reverse engineering is legally permissible if the information was lawfully obtained. B. Trade secrets are automatically invalidated if any part of the design is available publicly. C. The company retains trade secret protection as long as it never publicly disclosed its design process. D. The supplier must prove that it did not hire former employees from the aerospace company. Answer A. Reverse engineering is legally permissible if the information was lawfully obtained. Explanation: reverse engineering is a lawful method of obtaining trade secrets provided it is done through legitimate means. Courts have ruled that if a competitor legally acquires a product and reverse engineers it without breaching agreements or using stolen data, no misappropriation has occurred. See Q&E Oil Company v. Bicron Corp. Option B is incorrect because publicly available information does not automatically invalidate trade secret claims, only if it reveals the confidential method itself. Option C is incorrect because trade secret protection is lost if competitor can obtain the information through legal reverse engineering. Option D is incorrect because hiring former employees is not inherently illegal unless done with the intent of extracting trade secrets. Question 17. In a large organization where multiple departments need to coordinate, a security breach exposes confidential customer data across multiple divisions. While investigating the breach, the department finds evidence that an insider may have leaked credentials to an external hacker. What legal and operational steps should the company take to mitigate risks and prevent future incidents? A. Conduct a thorough forensic audit and report the breach to regulatory authorities. B. Immediately fire all employees who had access to the compromised data. C. Delay disclosure of the breach to the public until the company resolves all security issues. D. Assume the breach was accidental and avoid legal action to preserve company morale. Answer A. Conduct a thorough forensic audit and report the breach to regulatory authorities. Explanation: under data protection laws like the GDPR for EU companies and US state breach notification laws, companies must immediately investigate, contain the breach, and notify affected parties. A forensic audit can help determine how the breach occurred and whether an insider was involved. See US v. Nozzle for insider cybercrime cases. Option B is incorrect because mass terminations without evidence may lead to wrongful dismissal claims. Option C is incorrect because delaying disclosure can lead to fines and reputational damage. Option D is incorrect because even accidental breaches can result in liability if negligence is found. Question 18. During a critical transition period where existing processes are being digitized, a logistics company faces resistance from employees who fear job displacement due to automation. How should leadership address these concerns while ensuring A smooth transition. A. Offer reskilling programs and ensure open communication about job roles. B. Ignore resistance and push for automation as quickly as possible. C. Replace employees who resist the transition with new hires skilled in digital systems. D. Delay automation until all employees feel comfortable with the changes. Answer A. Offer reskilling programs and ensure open communication about job roles. Explanation: employee resistance to automation is common. Studies suggest that reskilling and clear communication reduce opposition and improve adoption rates. See Harvard Business Review research on change management. Training programs and phased transitions allow employees to adapt while retaining institutional knowledge. Option B is incorrect because ignoring concerns can create long-term dissatisfaction. Option C is incorrect because replacing employees is costly and disrupts organizational stability. Option D is incorrect because delaying innovation can hurt competitiveness. Question 19. When dealing with a complex system that shows occasional failures, an aerospace manufacturer notices inconsistencies in its aircraft software updates. Some planes receive patches correctly, while others experience malfunctions. What troubleshooting approach should the company take to ensure safety and compliance? A. Implement rigorous testing protocols before deployment and analyze failure patterns. B. Revert to previous software versions without investigating the cause. C. Assume pilots will manually correct any system failures during flight. D. Stop all software updates indefinitely to avoid further risk. Answer A. Implement rigorous testing protocols before deployment and analyze failure patterns. Explanation: aerospace software must meet FAA/EASA safety regulations. Failure to conduct thorough testing before deployment could lead to liability for accidents. See Boeing 737 MAX investigations. Pattern analysis can identify if failures are due to hardware variances, network errors, or coding issues. Option B is incorrect because reverting without understanding the issue may not fix the problem. Option C is incorrect because human error is a major risk factor and pilots cannot be expected to compensate for software flaws. Option D is incorrect because pausing all updates indefinitely could lead to cybersecurity vulnerabilities. Question 20. In a high-stakes environment where multiple challenges must be managed simultaneously, a hospital is transitioning to a new patient record system while dealing with an ongoing nursing shortage. What should leadership prioritize to maintain patient care quality? A. Phase in the new system gradually while providing comprehensive training to staff. B. Roll out the system immediately to avoid further delays despite staffing issues. C. Delay implementation of the system until staffing levels improve. D. Outsource patient care to temporary contractors during the transition. Answer A. Phase in the new system gradually while providing comprehensive training to staff. Explanation: a gradual rollout with staff training minimizes disruptions. Healthcare transitions must comply with HIPAA and ensure continuity of patient care. CMA adoption challenges in healthcare studies. Option B is incorrect because the rushed rollout can lead to operational breakdowns. Option C is incorrect because delaying indefinitely could result in compliance issues. Option D is incorrect because temporary staff may lack familiarity with patient histories. Question 21. While investigating a complicated issue between different branches of an international bank, compliance officers discover conflicting regulatory requirements between the U.S. and EU laws. How should the bank handle these conflicts? A. Adopt the strictest applicable regulations to ensure global compliance. B. Follow only U.S. regulations since they apply to corporate headquarters. C. Choose the less restrictive regulations to reduce operational costs. D. Ignore regulations in non-primary markets unless explicitly fined. Answer A. Adopt the strictest applicable regulations to ensure global compliance. Explanation: multinational banks must adhere to the strictest applicable regulations to avoid legal penalties. GDR versus U.S. banking laws. Non-compliance can lead to fines, lawsuits, and reputational damage. Option B is incorrect because EU laws still apply to EU-based transactions. Option C is incorrect because choosing weaker regulations increases legal risks. Option D is incorrect because proactive compliance is key in risk management. Question 22. When implementing new protocols in a shared environment, an energy company faces backlash after mandating new sustainability policies that increase operational costs. What approach can management take to gain employee and stakeholder buy-in? A. Communicate the long-term benefits and provide financial incentives for compliance. B. Enforce policies strictly without consideration for resistance. C. Allow departments to opt out if they disagree. D. Abandon the sustainability initiative to maintain short-term profits. Answer: A. Communicate the long-term benefits and provide financial incentives for compliance. Explanation: Successful sustainability initiatives require stakeholder engagement and incentive structures. See corporate sustainability reports. Resistance can be mitigated through clear communication of long-term savings, regulatory benefits, and reputation advantages. Option B is incorrect because strict enforcement without engagement leads to resistance. Option C is incorrect because inconsistency weakens corporate policy. Option D is incorrect because sustainability is a long-term competitive advantage. Question 23. In a scenario where efficiency decreases across multiple business units, a retail company finds that supply chain delays are increasing operational costs. What corrective action should management prioritize? A. Invest in predictive analytics to anticipate disruptions and optimize logistics. B. Penalize suppliers for delays without investigating root causes. C. Increase warehouse stockpiling to compensate for inconsistencies. D. Reduce order volumes to minimize financial risk. Answer: A. Invest in predictive analytics to anticipate disruptions and optimize logistics. Explanation: Predictive analytics can reduce supply chain inefficiencies by identifying patterns and disruptions before they escalate. See AI in supply chain management studies. Option B is incorrect because penalizing suppliers may damage relationships. Option C is incorrect because overstocking increases storage costs. Option D is incorrect because reducing orders may lead to revenue loss. Question 24. During a major transformation where existing methods are being phased out, a government agency is transitioning from a paper-based record-keeping system to a fully digital database. However, employees report frequent errors in data entry and retrieval, slowing down operations. What strategy should leadership implement to ensure a smoother transition? A. Provide comprehensive training and introduce AI-driven verification tools to reduce errors. B. Completely halt the transition until all employees are fully comfortable with the new system. C. Dismiss employees who struggle with the digital transition to encourage faster adaptation. D. Maintain both the paper-based and digital systems indefinitely to avoid disruptions. Answer: A. Provide comprehensive training and introduce AI-driven verification tools to reduce errors. Explanation: A structured transition plan, including staff training and AI-driven verification, minimizes errors while ensuring compliance with data security regulations, e.g., FISMA in the U.S. Studies show that hybrid learning approaches, hands-on training plus digital guides, improve adoption rates during government technology shifts. Option B is incorrect because delays increase costs and create inefficiencies. Option C is incorrect because dismissing employees prematurely could lead to labor disputes and talent loss. Option D is incorrect because dual systems create inconsistencies and higher operational costs. Question 25. When developing a solution that must address opposing needs, a software company designing a cloud storage platform faces tension between security teams prioritizing strict encryption and product teams advocating for ease of access. What is the best way to balance these competing requirements? A. Implement role-based access controls with end-to-end encryption to balance security and usability. B. Prioritize ease of access over security to ensure a smooth user experience. C. Favor strict encryption even if it reduces usability and slows down operations. D. Allow each department to implement its preferred approach independently. Answer: A. Implement role-based access controls with end-to-end encryption to balance security and usability. Explanation: Role-based access controls ensure that users access only the data they need, maintaining security without compromising usability. End-to-end encryption protects data while still allowing efficient workflows. See NIST cybersecurity guidelines. Option B is incorrect because prioritizing ease of access over security increases breach risks. Option C is incorrect because overly restrictive security may alienate users and reduce adoption. Option D is incorrect because inconsistent policies across teams create compliance issues. Question 26. While analyzing the root causes of sequential problems in an industrial supply chain, a multinational corporation identifies recurring raw material shortages. What is the most effective long-term solution to stabilize supply chain operations? A. Diversify suppliers across multiple regions to reduce dependency on any single source. B. Stockpile excess raw materials regardless of fluctuating demand. C. Rely solely on automation and AI-driven forecasting without supplier adjustments. D. Accept shortages as an unavoidable aspect of global trade and avoid intervention. Answer: A. Diversify suppliers across multiple regions to reduce dependency on any single source. Explanation: diversifying suppliers reduces vulnerability to geopolitical risks, trade restrictions, and local disruptions. See Toyota's risk mitigation strategies post-2011 tsunami. Strategic partnerships and local sourcing options provide resilience against unforeseen supply chain breakdowns. Option B is incorrect because stockpiling can lead to excessive costs and waste. Option C is incorrect because automation alone cannot resolve supply-side vulnerabilities. Option D is incorrect because proactive risk management is critical for business stability. Question 27. During an emergency response where multiple areas are impacted, a national telecom provider experiences a major network outage due to a cyber attack. With millions of customers affected, what should be the company's immediate course of action? A. Activate the incident response plan, isolate affected systems, and communicate transparently with customers. B. Keep the issue confidential to avoid public panic and reputational damage. C. Immediately restore full access without investigating the security breach. D. Blame external contractors and shift responsibility away from the company. Answer: A. Activate the incident response plan, isolate affected systems, and communicate transparently with customers. Explanation: a structured incident response involves isolating compromised systems, conducting forensic analysis, and keeping customers informed. See NIST cybersecurity framework. Major companies like Equifax and Colonial Pipeline faced severe criticism for delayed or opaque responses to cyber attacks. Option B is incorrect because hiding information erodes public trust and may violate regulatory requirements. Option C is incorrect because restoring access without resolving vulnerabilities invites further attacks. Option D is incorrect because shifting blame damages industry relationships and does not resolve the crisis. Question 28. In a situation where formal requirements conflict with operational realities, a pharmaceutical company must comply with new government regulations that require changes in drug labeling. However, these changes significantly delay production. How should the company balance compliance with efficiency? A. Implement an automated labeling system to accelerate compliance while minimizing production delays. B. Continue using the old labeling process and challenge the regulations legally. C. Halt production until regulatory agencies reconsider the new guidelines. D. Ignore minor regulatory changes to maintain production speed. Answer: A. Implement an automated labeling system to accelerate compliance while minimizing production delays. Explanation: automated labeling systems reduce human error and accelerate compliance, ensuring that production continues efficiently while meeting FDA and EMAC guidelines. Companies like Pfizer and Merck have successfully used automation to adapt to changing regulatory environments. Option B is incorrect because delaying compliance can result in fines or product recalls. Option C is incorrect because pausing production indefinitely leads to financial losses. Option D is incorrect because regulatory non-compliance can lead to severe legal consequences. Question 29. While examining inconsistencies across various units in a multinational company, the leadership team finds that different regional branches report vastly different financial performance despite similar market conditions. What is the best approach to ensure consistent financial reporting? A. Standardize reporting procedures and implement centralized auditing across all regions. B. Allow each regional office to maintain its own financial reporting standards. C. Focus only on underperforming regions and ignore discrepancies in high-performing ones. D. Modify financial reports based on management's expectations rather than actual data. Answer: A. Standardize reporting procedures and implement centralized auditing across all regions. Explanation: standardized reporting procedures reduce errors, prevent fraud, and ensure compliance with global financial regulations like IFRS and GOP. Centralized auditing enables real-time monitoring of financial discrepancies. Option B is incorrect because lack of consistency can lead to inaccurate company-wide assessments. Option C is incorrect because even high-performing regions may have financial irregularities. Option D is incorrect because manipulating financial reports can lead to legal consequences. See Enron scandal. Question 30. During a seamless transition where continuity must be maintained, a healthcare provider is migrating patient records to a new digital platform. However, unexpected system outages threaten to disrupt patient care. What steps should be taken to minimize risks? A. Establish backup systems, conduct live testing, and train staff on emergency procedures. B. Proceed with the migration despite the outages and address issues later. C. Revert to paper-based records permanently to avoid future outages. D. Delay migration indefinitely to prevent further disruptions. Answer: A. Establish backup systems, conduct live testing, and train staff on emergency procedures. Explanation: a well-planned data migration strategy includes redundant backup systems, staff training, and real-time testing to minimize disruptions. See best practices from Mayo Clinic's digital transformation. Fail-safe procedures ensure continuity of critical healthcare services. Option B is incorrect because unresolved outages can result in medical errors. Option C is incorrect because reverting to paper records is inefficient and non-compliant with HIPAA. Option D is incorrect because indefinite delays can hinder technological progress.